Oh wow, it cut me off. Okay, sorry. Let's carry on. Whew. The defendant's incentive to flee, outlined above, coupled with the defendant's seemingly limitless resources, create significant risk of non-appearance. The defendant's net worth is publicly estimated at being close to $1 billion. Indeed, the investigation of this case has revealed that the defendant has access to vast funds and resources, including deep reserves of cash, which would facilitate his evasion of prosecution. And I guess if he's doing obviously like they're accusing him of human trafficking and all that kind of stuff, who knows how much money exactly. And I think they say like human it's actually like one of the biggest things in the world that makes like the most money, and I guess difficult to even know how much, right? Because it's not on paper. So that's so fucked up. Anyway, okay, let's stay professional here. Okay. Deep reserves of cash which facilitate his evasion of prosecution. At least as of December 2023, defendant had access to dozens of bank accounts, some personal and many under corporate entities, which contain millions of dollars. Additionally, as of December 2023, the defendant had over $1 million in personal cash on hand. The defendant has traveled internationally several times per year since at least 2006, and since approximately 2019 has owned a personal plane on which he has traveled internationally. The defendant maintains two primary residences in Los Angeles and Miami. In addition to his private plane, the defendant owns multiple vehicles in multiple locations. He has a personal staff, including assistants, security, chefs, trainers, and others, who perform tasks at his command, including transporting him, delivering him currency, securing narcotics for him, and other tasks. Jeez, imagine that's your boss. Fuck. And he is extraordinarily well, allegedly. And he is extraordinarily well connected both within and outside the entertainment industry. In short, if the defendant wanted to flee, he has the money, manpower, and tools to do so quickly and without detection. Also, remember those like parties that he used to throw for celebrities? Diddy's white party? A lot of A-list celebrities would go to those. Just saying. The defendant's lack of access to his passport or private jet would not negate the fact that the defendant could easily buy his way out of facing justice. As discussed below, the defendant's legal team has attempted to mitigate the substantial risk of flight by taking steps such as taking his family's passports, attempting to sell his plane, and reporting his whereabouts to the government. These steps have been taken with the precise goal of crafting an argument for bail before the court. While the defendant may have made the calculated decision in consultation with his attorneys not to flee before any charges were filed, that calculus inevitably changes today when an indictment charging the defendant with extremely serious offenses carrying enormous potential penalties was unsealed. He is now, for the first time in his life, facing a mandatory minimum term of imprisonment of 15 years and a maximum term of imprisonment of life, in which the government is prepared to prove the charges against him by, among other things, the testimony of dozens of witnesses and victims to his serial abuse, and evidence from dozens of his own electronic devices and those of his co-conspirators. Given the serious nature of the charges, the strength of the evidence, and the defendant's access to vast amounts of resources, his risk of flight is more pronounced today than it has ever been. In considering the danger and risk of flight presented by the defendant, the court is also required to consider the weight of the evidence against the defendant. The defendant faces a strong and powerful case here, only magnifying the danger he could present to others, especially victims and witnesses ready to testify against him, and the risk he flees. The evidence in this case consists of a vast amount of victim and witness testimony, electronic evidence, physical evidence, and subpoena returns and other voluntary productions, among other things. As to witnesses to date, the government has conducted interviews with over 50 victims and witnesses, many of whom saw or experienced the victim's abuse. Many of these witnesses corroborate one another, and their accounts are similarly consistent with the other types of evidence discussed below. The government only expects that number to continue to grow, given that the investigation, which is now public, is ongoing. The electronic evidence is similarly vast. The government has sought and obtained numerous search warrants for such evidence, in addition to obtaining evidence voluntarily from certain victims and witnesses. Setting aside devices seized in connection with the defendant's arrest, the government has obtained over 90 cell phones, laptops, and cloud storage accounts, as well as over 30 other electronic and storage devices, such as hard drives, thumb drives, cameras, and a surveillance system. I actually saw a video of him, like, out in public, like, the person just, like, got out of a car, he started patting them down, like, literally, apparently looking for a wire. Like, that's nuts. The electronic data comes from the defendant himself, as well as co-conspirators, victims, and witnesses, and chronicles much of the defendant's criminal activity as it occurs. Also, side note, if someone's doing that in public, that's definitely like a red flag on that person. Also, you're in a public place, you know? It's like you don't have the expectation of privacy. So the fact that you're doing all that, that's a red flag for sure. The evidence also consists of physical evidence, which was seized pursuant to search warrants executed at the defendant's residences in Los Angeles and Miami, as well as on his person and the persons of certain co-conspirators. In addition to the firearms and electronics discussed above, the physical evidence also includes other evidence of freak-offs, including over 1,000 bottles of baby oil and personal lubricant. I'm sorry, that's so disturbing to me. Like, I actually had read people asking, like, oh, what would you do with that? And they actually, like, were trying to make jokes of it. I was like, dude, that is so fucking disturbing. Like, think about what he's being alleged to be doing. 1,000 bottles of baby oil and lube. That's a lot of trafficking alleged. But 1,000? Think about it. Like, just really think about it. That's pretty fucked up. Finally, the evidence includes records obtained pursuant to over 300 grand jury subpoenas and other voluntary productions. These materials come from over 100 entities and individuals, including communications providers, tech companies, social media companies, banks, and other financial institutions, airlines, hotels, car services, and other travel-related companies, escort services, and even the defendant's companies and wealth management firm. Together, this evidence, as well as other evidence gathered, powerfully demonstrates the defendant's guilt and counsels in favor of detention. The defendant's proposed bail package is insufficient. For all the reasons set forth herein, there is no bail package that can reasonably assure the safety of others in this case, where the defendant has engaged in decades-long pattern of violence against women and others, and has used his wealth and power to ensure his criminal conduct goes unpunished through manipulative and obstructive conduct. In particular, the bail package proposed by defense counsel is insufficient because it fails to adequately protect others from the defendant's violence, impose measures to protect and prevent obstruction, or prevent the defendant from accessing his vast resources, including millions of dollars in cash, to evade prosecution or dissipating those assets to avoid financial penalties for his crimes. Defense counsel has proposed certain bail conditions, including home detention with electronic monitoring and $50 million bond secured by the defendant's Miami property. These conditions are plainly insufficient to address legitimate concerns set out above. In particular, given the defendant's history of engaging in obstructive conduct, the court must reject the insufficient conditions proposed by defense counsel, which do nothing to prevent and detect such conduct. For example, in United States v. Ferranti, a case in which the defendant was charged with witness tampering and where obstruction remained an ongoing concern, the Second Circuit reversed the district court's release of the defendant on bail conditions because the $1 million bond, which was to be secured by properties owned by the defendant and members of his family, only deterred flight, not danger. More specifically, the Second Circuit found the district court's bail condition intended to address witness tampering, which was a general prohibition that the defendant was not to commit a crime or intimidate a witness, which should go without saying. No, like, yeah, so just make sure you don't commit a crime. Like, I think that's a little too late for that, don't you think? Does not at all impede his ability to do so and requires no more of him than which the law already demands from a defendant and any other citizen. Notably, the defendant's previously proposed conditions do not include provisions related to his access to electronic devices, which, as outlined above, the defendant uses to engage in obstructive conduct. Nor do the proposed conditions include information related to or restrictions on access to the defendant's vast resources, including multiple personal bank accounts in the name of the defendant's businesses, and deep cash reserves, which could facilitate the defendant's flight. Similarly, the proposed conditions fail to protect against dissipation of assets, which may be subject to forfeiture or penalties on the charges in the indictment. Finally, the proposed conditions do not include conditions that would limit the defendant's potential to engage in violence or abuse, such as drug testing and treatment and surrender of all firearms. As set forth above, the defendant poses an ongoing and significant danger to the community, has repeatedly engaged in obstructive conduct, and presents a serious risk of flight. The government respectfully submits that the defendant cannot meet his burden of overcoming the statutory presumption in favor of detention. There are no conditions of bail that would assure the appearance and compliance of the defendant or the safety of others. Accordingly, any application for bail should be denied. Wow. So, I mean, as they kind of referred to earlier, like, they're not going to give out, like, the details. Like, they're going to save that for trial, but they're giving us, like, the gist. Just kind of trying to paint a picture of who this man is and what he's capable of. And it sounds like, even as the case or the investigation has been, which has been for a long time now, seems like he must have caught or had been catching wind of it. And so I guess the least, and as is always with law, like, the least amount of information you can give until it's, like, literally required. Like, you must give the information, like, by this time. You want to drag it out as long as you can in order for, like, your case, because then otherwise it gives the other person more time to respond or rebuttal or you know what I mean? So, but it sounds like this is going to get really dark, really heavy, and yeah, like I said, I'd mentioned, like, he would throw parties with A-list celebs all the time. That was, like, for celebrities, like, oh, the Diddy white party, like, that was the place, like, to be. So I wonder how deep this goes. I wonder who has either been involved or has been a part of this. And it just makes you think, like, how many of these evil people walk among us. Like, something about the entertainment business definitely seems to attract a lot of dark, evil people, and I'm glad that it's coming to light, and I'm glad that they're being exposed, and I'm glad that we are choosing, to stand a lot more for the victims, and it'll be definitely interesting to see what comes out of it. And of course, this is just allegations, but I remember, like, in the 90s, there's, like, whispers or conspiracy theories, really. Of course, or he would have already been, jailed up by now. But conspiracy theories, like, oh, perhaps maybe he had something to do with, like, either or the Tupac or Biggie deaths, but it was just like, I don't know details. It's just like whispers, conspiracy theories. And if I'm not mistaken, there was some kind of club thing that happened where I think Jennifer Lopez may or may not have. I don't. I never really was that big into rap, so I don't know like the particular details. But I do know that he always was kind of like, you know what I mean? He just came from that time where like rappers were like actually, used to slang back in the day, and they probably were like gangsters, and so like they may or may not have taken that energy still are